Hello, my name is Gabrielle Stritch. I'm an attorney, mediator, and collaborative lawyer. And today we're going to talk about what happens if someone close to you dies. Where do you even begin to deal with that? Well, the first thing you want to check is, do they have a will? And by the way, you really need an original will. If you only have a copy, you have to go to court and argue why it should be approved by the court. But assuming that you have a will, and hopefully this person has died of old age and natural causes and not from something horrible like COVID, you have to wait 10 days in New Jersey before you can submit the original will, a picture proof of identity, and an original death certificate to the surrogate in the county in which your relative died, or the person you're close to that you're worried about. And they, assuming they approve it, you will get a short executor certificate. This will enable you to get a tax ID for the estate and to open up an estate checking account with a convenient bank. You must keep track of any expense and any assets that you gather. It is your job to make sure you have all of the assets. And then once you've resolved all debts and you have all the assets, you have to carefully distribute consistent with the provisions of the will. It's my recommendation that you don't distribute until you send what I call an informal accounting with a release and refund bond to each beneficiary. Once they sign it, it protects you because they are agreeing to the accounting that is attached to the refund and release bond. And then you can distribute without any concerns. Does this sound like a lot of work? Oh, yes, it is. It's a lot of work. And I can help you do it all, soup to nuts, or we can just provide consultation on things like how to do the accounting. And once it's almost all done, you are entitled to get paid an executor commission as defined by statute. Well, what if there's no will? Then you need to apply to be an administrator, and you have to notify all potential beneficiaries of that intent. Only if no one objects will you be appointed an administrator. And unlike an executor, you will need to get a surety bond, and you need A-level credit to qualify for a surety bond. The estate will pay for it, but it's a high level of criteria. Then all the other things I talked about apply again. So if you don't know where to start, or you need help on the way, or you need me to do it all, call me, Gabrielle Stritch, at the contact information below.